Yes, let's take a look at this, and what was forwarded to me concerning a statement, a submission of the Attorney General of the Federal Republic of Nigeria, Mr. Fabemi, saying that no Nigerian law bars or prohibits the trial of minors. But I don't think that is correct, because look at the logic behind the United Nations Convention on the Right of the Child, which Nigeria is a signatory to and has duly ratified that international law instrument. The international law on the right of the child does not permit the trial of minors in certain conditions. Let's look at an Article 40 sub 3b of the United Nations Convention on the Right of the Child, which require countries to promote measures that deal with children in conflict with the law without resorting to judicial proceedings. These include the evasion measures which could take place before or during proceedings. The Convention on the Right of the Child also requires that countries treat children in a way that respects their human dignity and worth, and help reintegrate them into society. The Convention also states that children should not be accused of breaking the law for actions that were not prohibited at the time they were committed. The Convention guarantees that children have the right to be presumed innocent until proven guilty, and in any case, where the charges that is fashioned against children has to do with a mass action, such should not be directed to judicial proceedings. That the children have the right to legal assistance and a fair hearing, and should not be forced to confess and give testimony, to examine adverse witness, and have witnesses examined on their belief. So the United Nations really recognizes that children belong to a vulnerable group and came out with this law to protect the children, and recognizes that criminalizing children for status offenses such as baking, such as transit, such as running away is harmful, such as protests is harmful. They shouldn't be discriminated against. Let's look at Article 12 of the Convention of the United Nations Convention on the Right of the Child in particular, and it clearly provides that the children have the right to have their views heard and taken seriously. If you give an expansive interpretation to that, Article 12 of the Convention, you will realize that the right to have your views heard, or anyone's view heard, comprises the right to protest, to have the government, if that is the easiest way to have the governments to understand their grievances and their sovereign, the right to protest, that peaceful assembly, and to call on the attentions of the government to things that you feel that are not proper. It's part of a community right that the children can invoke to make their voice heard, or their voices heard by the government. Article 2 in particular says government action should be for the best interest and accounted for as a primary consideration of the child to have their rights to survive and develop. If you read that in conjunction with Article 3. So the United Nations Convention on the Right of the Child is an important legally binding agreement, a multilateral law instrument signed by 196 countries as of 12 July 2022. The Right of the Child of 1983, which is signed by 196 countries as of 12 July 2022, which aligns the fundamental right of every child, regardless of their religion, race, and abilities. It is the basis of all the work of member countries on the right of the child. If you look at this law, it has been ratified by Nigeria on the 24th day of March 1991. 24th day of March 1991. And the conventions articulate the right of every person under the age of 18, which is deemed to be a child, and identify the duty bearers responsible for the realization of its rights, which include the government. The Child Rights Act of Nigeria, Section 22 in particular, which reaffirm the fundamental principles of the UN Convention on the Right of the Child, emphasize the treatment of the child, that the treatment of the child in any case shall be to give primary importance to the best interest of the child, and no child shall be subjected to unfair nature. And in terms of emergencies, to prevent violence in the instant case that affected the minors that were arrested and arraigned by the police in Nigeria, in terms of emergency to prevent violence, abuse and exploitations, and displacement of children, and denial of the access to protection and all essential services should be avoided. Section 277 of the Child Rights Act 2003 in particular describes a child as a person under the 18 years of age, while Section 1 and 2 of the same laws state that every action shall be for the best interest of the child and should be as a Parliament consideration, regarded as Parliament consideration in all actions. The best interest of the child should be deemed as the paramount consideration in all action. The child has to be given protection and care for its well-being. So the actions by Nigerian government appear quite dramatic and not proper. And I have a problem with the attitude of attorney generals of these developed countries, third world countries. I have a problem with them. They always make themselves politicians. A man like Latif Fabemi is known in the practice of law in Nigeria and is known as a man of law, but having been appointed as Attorney General, he began to say things that are not true. No Nigerian law restrict or prohibit children from being prosecuted. That is not true. The prosecution of children must be in line with the professions and the purposes of the United Nations Convention on the Right of the Child, which has been ratified by Nigeria under the Child Rights Act, or by feature of the Child Rights Act. It has to be in line. The interests of the children must be the primary consideration, and in terms of emergencies to prevent violence, in the instance of protest, to prevent violence, that paramount interest must be put into consideration. That is the law. So I think the Nigerian ministers of justice, attorney general, should always try to distinguish themselves and try to separate the duty of serving the public and the law, acting as chief law officers of the country, from that of being a servant to the president or to the government. Maybe they will have to, or the Nigerians should call for separation of the office of Minister of Justice and Attorney General to be able to look at the situation of a country like United States of America. Under Biden, it was being recommended for prosecution by the Attorney General appointed by his father, Joe Biden. That's the distinction between the Department of Justice, the Attorney General, and the office of the President. He didn't say because it's the President's son and could not, and therefore should not be prosecuted. So the Attorney Generals in Nigeria, in the state and the federal level, should always try to distinguish themselves from political folks who are gaining for political interests. They shouldn't be sycophantic and begin to misinterpret the law and say things that are not proper, things that are not true, when the actual position of the law is different from what they are saying. It doesn't look good. I hope this message gets to them. Thank you and God bless.